The federal courthouse in Portland, Oregon, was not supposed to be the site of a historic moment. On the docket that morning sat what many in the legal community considered just another voting rights case. Significant but procedural, destined to be argued in dense legal language and resolved in quietly typed opinions. Yet from the moment Judge Mustafa Kasubhai entered Courtroom 3A, a sense of anticipation filled the air, as if those gathered sensed something more profound was about to unfold. Reporters filled the press benches, their pens and recorders poised. Law students lined the back rows, clutching notebooks, eager to witness what professors had promised would be an instructive case. Community members, many from neighborhoods affected by the contested voting procedures, occupied every available seat, and at the plaintiff's table sat Congresswoman Jasmine Crockett, an attorney with a history of civil rights advocacy. But visibly resolute. The judge's entrance was routine, but the atmosphere was not. Mustafa Kasubhai, a respected jurist known for his composure and meticulous reasoning, adjusted his glasses and surveyed the crowded courtroom. His voice, steady but resonant, carried easily as he instructed, "You may be seated." What followed, however, was anything but routine. Before calling the first attorney to speak, Judge Kasubhai paused. He leaned back slightly, as if measuring his words with the care of someone who knew they would carry weight far beyond the courtroom walls. "Before we proceed with today's hearing," he began, "I feel compelled to address something extraordinary contained in the filings of this case." A hush fell over the room. Even the faint shuffle of papers ceased. The judge removed his glasses, a small gesture, but one that signaled gravity. He looked directly at Congresswoman Crockett. "In my 15 years on the bench, I have never witnessed an attorney display such remarkable courage in the face of deliberate intimidation." A ripple passed through the gallery. Reporters glanced up from their notes. Attorneys shifted uncomfortably in their seats. Crockett, usually unflappable, straightened slightly, her expression measured but touched by the weight of his acknowledgement. Kasubhai continued. "The threats Congresswoman Crockett received after filing this case were reprehensible. Yet rather than retreat, she did something both bold and unprecedented. She incorporated those very threats into her amended complaint, transforming intimidation into evidence of the chilling effect on voting rights." The word struck like a gavel, reverberating across the courtroom. What the judge had done was extraordinary in itself. Federal judges rarely comment personally on attorneys during proceedings, let alone praise them in open court. For Kasubhai, known for his restraint, the choice was deliberate. He was not making a political statement, but affirming a principle. That courage in defense of democratic participation is not partisan, but foundational. The defense attorney at the opposite table adjusted his tie, careful to maintain composure. His clients, the county election board, were not responsible for the threats, but the shadow of those threats now hung heavily over the proceedings. Crockett, however, had turned fear into a weapon of advocacy, reframing intimidation as evidence of systemic suppression. The judge's remarks, though brief, set the tone. They told everyone present that this case was about more than polling sites and procedural statutes. It was about the resilience of democracy itself, and it framed Jasmine Crockett not just as an advocate but as a symbol of persistence in the face of fear. Outside that courtroom, America was already polarized. Debates over voting access, election security, and democratic legitimacy played out daily in news cycles and family dinners. Yet inside Courtroom 3A, something different was emerging. The framing shifted from partisan conflict to universal principle, the right to participate without intimidation. The tension of the moment built, as if every person inside the chamber was holding their breath, waiting to see where it might lead. And then, unexpectedly, it led to applause. It began softly, a single clap from the back row. At first, courtroom observers froze. Applause is strictly forbidden in federal courts. But then, another joined, and another, until the entire gallery was resonating with sound. Journalists, community members, even attorneys, people from opposing political beliefs rose together in recognition of courage. Kasubhai did not silence them. He watched, measured but unflinching, as the wave of applause filled his courtroom. He allowed it to crest and fade naturally, understanding that this was no partisan celebration, but a collective acknowledgement of democratic values. For Crockett, standing at the plaintiff's table, the moment was almost surreal. She had endured days of racist threats, nights of doubt about whether to press forward. She had feared not for her safety, but for the distraction it might cause to the case. And now, in a space designed for solemn order, she witnessed a rare breach of decorum, a breach born not of disrespect, but of reverence. When the clapping subsided, Crockett addressed the court with characteristic humility. "Whatever courage I may have shown," she said, her voice steady, "pales in comparison to the courage of ordinary citizens who persist in voting, despite obstacles and intimidation. They are the true inspiration behind this case." Her words redirected the spotlight from herself to the communities she represented. grounding the moment not in personal valor but in democratic principle. It was a choice that elevated her from symbol to servant, reminding all present of the real stakes: the voters whose access had been curtailed. The judge nodded, acknowledging her response before guiding the hearing back to legal arguments. But the moment lingered. Reporters scribbled furiously, law students whispered to one another, and community members exchanged glances that conveyed both pride and recognition. They had witnessed something historic, not because of a ruling or a precedent, but because of the affirmation of courage in a time when fear was too often rewarded. Later that day, news outlets across the spectrum would carry the story. Progressive commentators highlighted Crockett's strategy. Conservative outlets acknowledged the principle of resisting intimidation, and legal scholars dissected the implications of incorporating threats into a civil rights case. Social media lit up with clips of the applause, hashtags like #courage in court trending within hours. But in that moment, in the echo of hands meeting in unity, something rare had happened. For a fleeting instant, partisanship dissolved. Americans from different sides of the aisle recognized a shared truth: that courage in defense of democracy is worthy of respect, regardless of ideology. And this was only the beginning of what would become a case studied in law schools, cited in ethics courses, and remembered as a moment when principle transcended politics. The opening act had concluded, and the story of courage, law, and democracy was just beginning. The applause in courtroom 3A might have lasted only a minute, but the reverberations carried far beyond those walls. By the time the hearing recessed for lunch, the courthouse steps had become a makeshift press stage. Microphones clustered, cameras lined up, and reporters pressed forward to capture every word. Jasmine Crockett emerged into the September sun. Flanked by her legal team, her expression measured yet undeniably charged by what had unfolded inside. Congresswoman Crockett, how does it feel to receive such a rare public acknowledgement from Judge Kasubhai? One journalist called out. She paused before answering, allowing the noise of the crowd to settle. This case isn't about me, she said firmly. It's about protecting the right to vote for every citizen, free from fear or intimidation. I am humbled by the judge's words. But the true recognition belongs to the voters who stand in line, who face obstacles, who still believe their voices matter. The response was direct, principled, and strategic. By shifting the spotlight away from herself, Crockett reinforced the idea that she was not seeking personal glory, but defending a broader principle. The cameras captured every syllable, and within hours the clip would circulate across television broadcasts and digital platforms. Yet what most viewers wouldn't see was what happened next. As the crowd of reporters dispersed, Crockett was approached quietly by an elderly man, leaning heavily on a cane. He introduced himself as a retired schoolteacher from a small town outside the city. His voice trembled as he spoke. Ma'am, I just wanted to thank you. I was told last year that my polling place had been moved miles away, and when I tried to vote, I felt like I wasn't supposed to be there. I nearly gave up. But seeing you stand up in court today reminded me why I can't. Crockett placed a hand gently on his shoulder. You were always supposed to be there, she told him. That's exactly why we fight. The exchange lasted less than a minute, but it encapsulated the stakes of the trial. Not abstract statutes, but flesh and blood citizens. People who carried both the weight of history and the hope of the future in their right to cast a ballot. Inside, the defense prepared its arguments. Their attorney, a seasoned litigator named Michael Thornton, had built a career on representing state agencies. He was no villain, no caricature of oppression, but a professional tasked with defending the county's procedures. Thornton's strategy was methodical, emphasized compliance with statutory requirements, highlight administrative constraints, and insist that any burdens on voters were incidental rather than intentional. Your Honor, Thornton began, his voice steady and professional. The county has complied with every legal requirement. The relocation of polling sites was based on logistical considerations, building capacity, parking access, ADA compliance. There was no intention to suppress votes. Kasubhai listened attentively, his expression impassive. Thornton continued, we acknowledge the plaintiff's concerns, but federal courts are not venues for political debates. They are for adjudicating law, and the law requires evidence of systemic intent, not anecdotal fear. It was a carefully calibrated argument, one designed to appeal to precedent and procedure. But Crockett, in her rebuttal, knew the strength of her case lay in reframing those very terms. Your Honor, she began, rising to her feet, the law is not blind to reality. When polling sites are moved disproportionately from minority neighborhoods, when threats target attorneys for daring to challenge these practices, when voters themselves testify to intimidation, intent is not just about what the county claims. Intent is revealed in the consequences. Her words carried weight because they fused legal reasoning with lived experience. She cited affidavits, data analysis, and testimony, but she wrapped them in a narrative that connected cold numbers to human impact. Where Thornton's arguments felt clinical, Crockett's resonated as lived truth. The contrast was stark. and the observers felt it. Law students scribbled furiously, professors nodded quietly, and community members leaned forward. In their seats, the defense had law on its side in the narrowest sense, but Crockett wielded both law and moral clarity, weaving them into a force greater than precedent alone. During a brief recess, the gallery buzzed with conversation. One student whispered to another, "This is going to be in our textbooks." A journalist typed furiously, already shaping the headline. But for Crockett, the recess was no time for rest. She retreated with her legal team to a small conference room, reviewing documents, strategizing over closing arguments. The threats she had received were still fresh in her memory, but she carried them now as fuel rather than fear. "We have to stay sharp," she reminded her team. "They're going to argue this is about logistics. We need to keep showing it's about people." Her co-counsel, a young attorney named Sofia Alvarez, nodded. "The testimony from the church voters is critical. It shows not just inconvenience, but exclusion." Crockett agreed. "Exactly. We keep it rooted in their stories. That's where the power is." The second half of the hearing resumed, and with it, the stakes rose higher. Thornton presented charts and logistical reports. He cited budgetary constraints, staffing shortages, and fire code compliance. Every claim was polished, precise, designed to withstand appellate scrutiny. Crockett responded not by dismissing his facts, but by reframing them. "The county argues these relocations are neutral. But neutrality that results in disenfranchisement is not neutrality at all. It is impact without accountability. And when those most affected are disproportionately from communities of color, the law requires us to look deeper." Her phrasing, "impact without accountability," landed like a stone in water, sending ripples across the courtroom. Even Thornton, seasoned as he was, recognized its rhetorical force. By late afternoon, fatigue set in. Hours of testimony and argument had stretched the patience of even the most dedicated observers. Yet the atmosphere never slackened. The memory of applause still lingered, an undercurrent reminding everyone that this was more than procedure, was principle. As the session adjourned for the day, Kasubhai addressed both sides. "This court will continue tomorrow. In the meantime, I urge counsel and the public to reflect on what has been presented. The law is not served by haste, but by careful consideration." The gavel fell, and the crowd slowly dispersed. Outside, the courthouse steps once again became a stage, this time for a spontaneous gathering. Civil rights activists held signs reading "Courage is contagious" and "Protect every voter." Students clustered in circles, debating strategy, quoting Crockett's phrasing as though it were already canon. And amid the crowd, Crockett stood quietly, speaking one-on-one with citizens who approached her. Some offered thanks, some shared personal stories of voting struggles, and others simply wanted to shake her hand. Each encounter reinforced the reality that this case was not confined to legal arguments. It was about the lived experience of democracy itself. For observers, the day's events marked a turning point. What began as a case about polling logistics had become a national story about courage, intimidation, and the meaning of participation. And though the verdict remained far off, one thing was already certain: history had taken note. By the second morning of testimony, the courthouse was overflowing. Word of the previous day's events had spread quickly, amplified by headlines and social media. Students who had skipped lectures, activists who had driven from neighboring states, and curious citizens who had never set foot in a federal building all crowded the marble corridors in hopes of finding a seat. Even those turned away at security lingered outside, forming clusters around portable speakers broadcasting live coverage. Inside, the courtroom hummed with anticipation. Judge Kasubhai entered with his usual calm, but the atmosphere was anything but ordinary. Everyone knew that the case had transcended local boundaries. This was no longer just Crockett v. County Board, it had become a referendum on the courage required to defend democracy. The morning began with testimony from voters directly affected by the relocation of polling sites. The first witness, a middle-aged nurse named Angela Price, described how she had driven to her usual church polling location only to find it closed. The new site was across town, requiring 2 bus transfers and nearly 2 hours of travel. "I couldn't make it before my shift," she testified, her voice steady but tinged with frustration. "I've voted in every election since I turned 18. That was the first time I ever missed one. It felt like I was erased." Crockett guided her gently through the testimony, never dramatizing, but allowing Angela's words to carry their natural weight. The effect was powerful. Observers scribbled notes, while the defense attorney prepared to cross-examine. Thornton rose, polite but precise. "Ms. Price, you acknowledged that the new polling site was open all day, correct?" "Yes," she replied, "and the county provided notice of the relocation by mail. I received a postcard, but it came 2 days before the election." Thornton nodded, pressing on. "So the issue wasn't that you couldn't vote, but that you couldn't rearrange your schedule in time." Angela paused, her eyes narrowing. "The issue, sir, is that the rules changed in a way that made it impossible for me and many others to participate." Voting isn't just about technical possibility, it's about fair access. Her answer landed harder than any prepared rebuttal. Even a few members of the gallery nodded in silent agreement. Next came testimony from a college student, Jamal Henderson, who described waiting in line for 3 hours at the relocated polling site, only to be told his registration had been purged. "I did everything right," Jamal insisted, his voice rising with emotion. "I registered on time, I showed up with ID, but they said the system didn't show my name anymore. I walked out feeling like I didn't matter." Again, Thornton cross-examined, pointing out that clerical errors occur in every election, but Crockett seized the opportunity in redirect. "Jamal," she asked gently, "when you left that polling place, how did it make you feel about the value of your voice in our democracy?" He swallowed hard before answering. "It made me feel like my country didn't want me to belong." A heavy silence followed, broken only by the scratch of pens and the clicking of camera shutters. Crockett didn't need to add commentary. The testimony itself was indictment enough. By mid-morning, it was clear the case had shifted. Thornton's defense that the county was simply following procedure remained intact legally, but emotionally, he was losing ground. Each witness reinforced Crockett's narrative that laws are meaningless if their implementation silences the very people they are meant to serve. During a break, 2 law professors in the gallery debated in hushed tones. One argued that Thornton's case was technically strong, built on precedent and statutory compliance. The other countered that Crockett's framing impact over intent was gaining traction in the judge's mind. "She's not just litigating the law," the professor observed, "she's litigating the conscience of the court." The second witness session concluded with a retired veteran, Robert Martinez, who recounted traveling to the new polling site only to find the building inaccessible for his wheelchair. "They told me there was another entrance," he said, "but it was locked. I waited 30 minutes before someone finally let me in. By then, I was exhausted. It shouldn't be that hard for someone who served this country to cast a vote." His words brought the courtroom to the edge of tears. Crockett, maintaining her composure, placed her hand lightly on the table, grounding herself before thanking him for his service and his testimony. When the judge recessed for lunch, the gallery erupted not in applause this time, but in a collective hum of voices, buzzing with urgency. Outside, cameras captured activists holding signs with Robert's words, "It shouldn't be that hard." Over sandwiches in a side conference room, Crockett and her team regrouped. "They're telling the story better than we ever could," Alvarez noted, referring to the witnesses. "The defense can argue logistics all day, but it doesn't erase lived reality." Crockett nodded. "We have to keep bridging the gap between the law and the lives it affects. That's where our strength lies." That afternoon, Thornton shifted tactics. Recognizing the emotional impact of the testimony, he began stressing the county's limited resources, painting a picture of overworked staff and strained budgets. "The county isn't perfect," he admitted, "but imperfection is not discrimination. We must not conflate hardship with intent." It was a clever move, one designed to humanize the bureaucracy rather than defend it coldly. Yet Crockett was ready. Rising for her response, she acknowledged the strain on county officials but reframed it. "Your Honor, the law does not excuse harm simply because it was unintentional. If a building is unsafe, we do not excuse the injury because the owner lacked funds for repairs. We hold them accountable. Democracy deserves no less protection." The gallery stirred, sensing the force of the analogy. Kasubhai leaned back, steepling his fingers, his face inscrutable. But those who knew him recognized the subtle signal. He was weighing deeply. As the day drew to a close, Crockett delivered a quiet but resonant statement. "This case is not about villains or heroes. It is about choices that determine whether access to the ballot is expanded or constricted. The threats I received were meant to silence me, but they will not silence the voices of the people who stand behind me. That is what's at stake." Her words lingered as the gavel fell. The courtroom emptied, but the energy carried into the streets. Local news stations led with images of Angela, Jamal, and Robert. National commentators framed the case as emblematic of the broader struggle for voting rights. Hashtags multiplied, with ordinary citizens sharing their own stories of voting obstacles under the banner, #Voices Matter. By the time Crockett returned to her hotel that night, her phone buzzed with messages from across the country. Colleagues in Congress sent encouragement. Civil rights groups offered support. Strangers shared their gratitude. And though she was weary, the Congresswoman sat quietly by the window, gazing at the city lights, reflecting on the day. She knew the fight was far from over. The law was slow, the opposition organized, the risks personal. But she also knew this: the tide of history does not shift overnight. It shifts in moments like these, moments when courage is acknowledged, when truth is spoken, when ordinary citizens step forward to testify that they will not be erased. Tomorrow, she would step back into courtroom 3A, and tomorrow, the story of courage and democracy would continue to unfold. The third day of proceedings began under gray skies. a light drizzle dampening the courthouse steps, but not the determination of those who gathered there. By now, the case had grown into a national spectacle. Cable news vans lined the street, satellite dishes pointed skyward, anchors delivering live reports from rain-slick sidewalks. The courthouse itself seemed to groan under the weight of history, as if its stone columns understood they were witnessing more than legal arguments, they were holding space for democracy on trial. Inside, the mood was somber but charged. Every seat was filled long before the bailiff called for order. A group of high school students sat wide-eyed in the gallery, their teacher whispering context between testimonies. At the press bench, correspondents tapped out quick dispatches, their editors demanding updates for breaking news tickers. Judge Kasubhai entered, as he always did, composed, meticulous, but even he could not fully mask the awareness that his courtroom had become a stage for the nation. He began briskly, reminding all present that decorum must be maintained, then nodded for the proceedings to resume. This day belonged to expert witnesses. Crockett's team called Dr. Elena Marquez, a political scientist specializing in voting access. She presented statistical models showing how polling relocations disproportionately impacted minority neighborhoods. Using maps, charts, and regression analyses, she demonstrated clear patterns, longer travel distances, reduced turnout, and systemic barriers that mirrored historical forms of suppression. Data does not lie, Dr. Marquez concluded. When you move polling sites away from communities of color at higher rates than from white communities, you are not simply rearranging logistics, you are disenfranchising voters. Thornton rose for cross-examination, careful to keep his tone respectful. Dr. Marquez, you agree that correlation does not equal causation? Of course, she replied, and you cannot definitively prove that the county intended to suppress votes. Correct. She leaned slightly forward. I can prove that the effect suppresses votes. And in civil rights law, effect matters. It was a subtle but devastating point, one that reinforced Crockett's central argument. Thornton pressed further, attempting to chip away at methodology, but each time, Dr. Marquez responded with steady confidence. By the time she stepped down, even skeptical observers admitted her testimony carried weight. Next came the defense's expert, a logistics consultant named Howard Green. He explained the county's reasoning: outdated facilities, inadequate parking, fire code violations. His testimony was polished, technical, and supported by binders of reports. Green insisted the relocations were driven solely by infrastructure constraints. Crockett's cross-examination was surgical. Mr. Green, she began, did your analysis include the demographic composition of the neighborhoods affected? No, that was outside the scope of my assignment. Did you evaluate the distance voters would have to travel to the new locations? Again, my role was to assess building capacity and compliance. So your analysis considered buildings, but not the people who must use them. Green hesitated, realizing the trap. That is correct. The contrast was stark. One expert framed democracy as numbers of voters, the other as square footage of buildings. Observers scribbled furiously, aware they had just witnessed the essence of the case distilled in a single exchange. By midday, the national media had seized upon the narrative. On cable networks, pundits debated whether Crockett's framing impact as intent could redefine voting rights litigation. Editorials appeared online, praising her courage and questioning the county's neutrality. Even late-night comedians referenced the unusual courtroom applause, framing it as proof that democracy could still inspire unity. Yet beneath the public spectacle lay private tension. Crockett, though outwardly composed, carried the weight of the threats that had followed her since the case began. Anonymous emails, voicemails filled with vitriol, online smears. The pressure was unrelenting. Her security detail remained discreet but vigilant, scanning crowds, monitoring entrances. One evening, returning to her hotel after a long day in court, Crockett found an envelope slipped under her door. Inside was a handwritten note: "Stop this, or you'll regret it." She sat on the bed, the note trembling slightly in her hands. For a moment, exhaustion threatened to overtake her resolve, but then she folded the paper carefully, placed it into a folder with the others, and whispered to herself, "They can threaten me, but they won't silence the truth." The following morning, she entered the courtroom as steady as ever. Her team noticed the tightness in her expression but said nothing, understanding that her silence was its own form of strength. As the defense rested its case, Kasubhai addressed the attorneys. "We will hear closing arguments tomorrow. Counsel should prepare accordingly." His voice was firm, underscoring the gravity of the moment. Outside, anticipation reached fever pitch. Protesters and supporters filled the plaza, their chants echoing off the courthouse walls. Some carried signs reading "Crockett equals courage." Others carried placards defending the county, warning against politicizing the law. The clash of perspectives was loud, but it was also proof that the case had captured the national imagination. That evening, Crockett prepared her closing with Alvarez and the rest of her team. She paced the room, speaking aloud as she refined her phrasing. This case isn't about perfection, she rehearsed, it's about protection. Protection of every citizen's right to be heard. The county wants to frame this as logistics, but democracy cannot be reduced to parking spaces and fire codes. It lives or dies in the lived experience of voters. Alvarez nodded, jotting down notes. Strong, but bring it back to the threats too. They show the stakes extend beyond procedure. Crockett agreed. Yes, because courage under intimidation is not just my story, it's the story of every voter who persists despite obstacles. The night stretched long, the team refining every sentence, every emphasis, until words became more than argument, they became conviction. When dawn broke, the rain had lifted. Sunlight spilled across the courthouse steps as crowds assembled once. Again, inside, the air was taut with expectation. This was the day the attorneys would distill weeks of testimony into their final appeals as she rose to deliver her closing. Jasmine Crockett drew a deep breath, grounding herself in the wake of history, all eyes fixed upon her. The nation waited, and with steady resolve, she began to speak. Your Honor, Jasmine Crockett began. Her voice calm but carrying through the hushed courtroom. This case asks a simple but profound question. Will every citizen of Rosemont County have an equal voice in our democracy? She let the question hang for a moment, scanning the faces before her jurors in the gallery of public opinion, though none held actual verdict power. What they witnessed mattered nonetheless. Over the past weeks, you have heard the county argue that this case is about logistics, that their decisions were driven by budgets, by buildings, by convenience. But democracy is not about convenience. It is about commitment. Commitment to the principle that no citizen should bear greater burdens than another simply to exercise the most basic right of a democracy, the right to vote. She walked a step closer to the bench, her hands open at her sides, her voice steady, but gathering power. The evidence has shown that 85% of the polling site closures occurred in neighborhoods where minorities make up the majority. These are not abstract statistics. These are communities where parents now must take 2 buses instead of 1, where elderly citizens face an extra mile of walking, where long lines grow longer and patience wears thinner. She shifted tone, softer now, almost conversational. Imagine being a first-time voter, excited to participate, but faced with hours of waiting while other neighborhoods vote with ease. What message does that send? It tells those citizens that their participation is not valued, that their voice does not matter as much. Crockett paused, letting the moral weight of her words settle. Then she pivoted. And then, Your Honor, there are the threats. Threats I received, not just as an attorney, not just as a congresswoman, but as a citizen daring to challenge unequal treatment. Those threats were vile, filled with slurs, filled with malice. I do not bring them before this court for sympathy. I bring them because they are evidence of the chilling effect that intimidation, combined with structural barriers, creates in a democracy. She lifted a sheet of paper, the printed threats, now part of the record. When citizens see what happened to me, they think, if they can threaten her, what will they do to me? That is the point. That is the design. To scare people out of exercising their rights. Her voice rose again, imbued with conviction. But democracy cannot survive if courage is punished. It survives when ordinary people, students, workers, seniors, parents show up, despite fear, despite barriers. This court must decide whether our laws protect that courage or whether they allow intimidation to succeed. Crockett stepped back, her tone measured once more. The county wants you to believe this case is about buildings, but what we have proven is that it is about burdens unequally placed on communities of color. Under Section 2 of the Voting Rights Act, under the Equal Protection Clause of the 14th Amendment, these burdens matter. They violate not just statute but the promise of our Constitution. She closed with a quiet intensity that drew the entire courtroom in. Your Honor, this is not about partisan advantage. It is about principle. It is about whether democracy in Rosemont County will be open to all, or reserved for some. The right to vote is the right that preserves all other rights. If we allow it to be eroded by intimidation and inequality, we erode the very foundation of this nation. I ask you to uphold the principle that has guided this court and this country since its founding, that every voice counts, and every citizen matters. When she finished, there was a long, pregnant silence. No one dared move. Even the hum of the air conditioner seemed muted, as though the building itself was listening. Then, Judge Kasubhai gave a slow, deliberate nod. Thank you, counsel, he said. Michael Thornton rose for the defense, buttoning his jacket with care. His tone was respectful but firm, a contrast to Crockett's passionate appeal. Your Honor, the county has not engaged in voter suppression. It has engaged in administration. Our election board faces the same challenges every local government faces: aging infrastructure, limited budgets, rising costs. The decisions at issue here were based on neutral, practical criteria: parking availability, building safety, compliance with codes, not race, not partisanship. He moved deliberately, careful not to overplay his hand. We acknowledge, without hesitation, the seriousness of the threats Congresswoman Crockett received. They are reprehensible. They do not reflect the values of my clients or this community, but they are the actions of anonymous individuals, not the county. To allow those threats to dictate judicial outcomes would be to let lawless actors influence justice, something none of us can permit. Thornton gestured toward his exhibits. The plaintiffs would have you believe that disproportionate impact equals discriminatory intent, but the Supreme Court has been clear. Not every impact rises to a violation. Voters still have access. Early voting remains available. Mail-in ballots remain accessible. The county has worked diligently to provide alternatives. His voice sharpened slightly. If this court rules that any change creating uneven impacts is unconstitutional, then no election board in America could function. Neutral decisions will always have uneven effects in a diverse society. That is reality. It is not discrimination. He softened again. In closing, Your Honor, the law demands balance. It demands that we distinguish between logistical necessity and intentional suppression. The county acted responsibly, within the law and with no intent to disenfranchise anyone. We ask that you recognize that distinction and rule accordingly. Thornton sat down, his expression composed but weary. Judge Kasubhai looked between the two attorneys, then addressed the room. I will take these arguments under advisement and issue a written decision in due course. Until then, this court remains adjourned. The gavel struck, but instead of the typical shuffling of feet and murmured goodbyes, something unexpected rippled through the chamber. For the second time in this case, the gallery broke into applause. Louder this time, more insistent, as though the first spark weeks earlier had now grown into a flame. Reporters scribbled furiously. Cameras outside were already live. In homes across America, viewers would soon see not just a legal dispute, but a moment where ordinary citizens affirmed courage, fairness, and principle. Crockett remained still at the podium, her eyes lowering. For a brief moment, humility softening her features. Thornton sat quietly, hands folded, recognizing that while he had argued the law, she had moved the heart. The applause swelled, echoing against marble walls, refusing to be silenced until the judge himself lifted a hand. Then, slowly, it faded, leaving behind a silence that felt charged with history. Outside the courthouse, the applause continued in another form, citizens gathering, cheering, chanting, debating. For a brief moment, democracy felt alive, not as an abstract idea, but as something pulsing in the voices of the people. Days passed before the decision came down, but the anticipation never waned. Outside the courthouse, protesters and supporters continued to gather daily, as though the building itself had become a temple of democracy. News anchors camped out on sidewalks, analysts speculated endlessly, and talk shows replayed clips of the dramatic applause inside the chamber. When the ruling was finally scheduled to be read, the courthouse once again filled to capacity. The atmosphere was different this time, charged not with uncertainty, but with the weight of impending history. People leaned forward in their seats, reporters readied their recorders, and the air carried the quiet hum of restrained anticipation. Judge Kasubhai entered with his usual calm dignity. He adjusted his glasses, shuffled his papers, and began to read. This court has considered the evidence, the testimony, and the arguments presented. At issue is whether the county's relocation of polling places resulted in a denial or abridgment of the right to vote on account of race, in violation of the Voting Rights Act and the Constitution. His voice was steady, deliberate, each word heavy with consequence. The defense argues these decisions were based on logistical concerns. The plaintiffs contend that the impact, regardless of stated intent, disproportionately burdened minority communities. The court recognizes that both considerations are significant. However, civil rights law has long held that discriminatory effect can establish liability, even absent explicit discriminatory intent. Kasubhai paused, glancing briefly toward Crockett. She met his gaze with steady composure. This court finds that the disproportionate impact on minority communities is undeniable, and that such impact constitutes an abridgment of the right to vote under Section 2 of the Voting Rights Act. Therefore, the plaintiff's claim is sustained. The county is ordered to reinstate polling locations in affected neighborhoods and implement safeguards to ensure equitable access going forward. The words landed like thunder. For a moment, silence reigned. Then, as if history itself exhaled, the chamber erupted, not with gasps this time, but with applause that shook the walls. People rose to their feet, clapping, cheering, some openly, weeping. It was not decorum, but it was democracy, alive in the flesh. Kasubhai rapped his gavel firmly. Order. This is still a court of law. Order. The applause gradually subsided, though the energy in the room could not be contained. Jasmine Crockett closed her eyes for a moment, allowing herself the briefest flicker of relief. Her team clasped hands, exchanging smiles and quiet tears. Thornton sat with his shoulders heavy, disappointment etched across his face, though he maintained professional restraint. Outside, the decision spread like wildfire. Within minutes, every major network interrupted programming with breaking news banners. Judge rules in favor of voting rights. Commentators spoke of a landmark case, one that could set precedent far beyond Rosemont County. Social media lit up with hashtags #CrocketCourage, #VotingRightsVictory, trending worldwide. In Washington, colleagues and rivals alike weighed in. Some praised the decision as a reaffirmation of civil rights. Others criticized it as judicial overreach. But regardless of perspective, no one could deny that Crockett had become a national figure overnight, not just a participant in politics, but a symbol of resilience. That evening, as the courthouse steps became a stage for spontaneous celebration, Crockett emerged with her team. Cameras flashed, microphones stretched forward, the crowd pressing close. She raised her hand, signaling for quiet. "This victory," she said, her voice carrying over the crowd, "is not mine. It belongs to the people of Rosemont County, and to every voter who has ever been told their voice doesn't matter." Today, the court affirmed what we have always known, that democracy cannot be rationed, and courage cannot be silenced. The crowd roared. Some shouted her name, others chanted "Every vote counts." The sound rose like a hymn of civic faith. Reporters peppered her with questions. "Congresswoman, what does this mean for the nation? Do you fear more threats after this ruling? Is this a step toward higher office for you?" Crockett smiled faintly, answering carefully. "This means that our democracy is stronger today than it was yesterday. As for threats, I will continue to do what I have always done, stand firm in the face of intimidation. And as for higher office," she paused, allowing a ripple of laughter to pass through the crowd. "My focus is right here, right now, on making sure every citizen can vote freely." Behind her, Alvarez whispered, "You just became bigger than this case." Crockett shook her head gently. "No, the people became bigger. That's the point." Over the next week, the ruling sparked ripple effects across the nation. Civil rights groups hailed it as a roadmap for challenging similar restrictions. Counties and other states quietly reassessed their polling relocations, wary of lawsuits. Law journals dissected Kasubhai's opinion, predicting appeals and higher court battles. But beyond the legal ramifications, something deeper shifted. Citizens who had grown weary, cynical, or disengaged suddenly felt the pulse of possibility again. They had watched a courtroom erupt with applause, watched a judge honor courage, watched democracy defended not in abstract speeches but in lived struggle. In coffee shops, on buses, in classrooms, people spoke of the case with unexpected passion. A teacher in Atlanta told her students, "This is why your vote matters." A grandmother in Phoenix mailed a letter to Crockett, thanking her for making us believe again. A college sophomore in Chicago tweeted, "I was thinking of skipping voting this year. Not anymore." And yet, with victory came new challenges. The threats against Crockett intensified, forcing her security detail to expand. Online trolls spread disinformation, questioning her motives. Political opponents painted her as a partisan radical, determined to reshape election law. She absorbed it all with the same calm resolve that had carried her through the trial. One night, sitting alone in her office, Crockett reflected on the journey. The applause still echoed in her memory, not as flattery, but as responsibility. She whispered to herself, "Now the real work begins." Because for Jasmine Crockett, the ruling was not an end, it was a beginning. Months later, the courthouse in Rosemont County looked the same as it always had: gray stone, tall columns, steps, worn smooth by decades of footsteps. But to those who had been there, it would never be just a courthouse again. It was now a landmark of democracy, a place where courage had turned into precedent, where applause had echoed against marble walls and carried across the nation. Ruling was cited in law schools, invoked in state legislatures, and analyzed in Supreme Court petitions. Scholars debated whether Kasubhai's reasoning signaled a new era for voting rights jurisprudence. Activists treated it as a rallying cry, evidence that persistence could bend even the most rigid systems toward fairness. For Crockett, the aftermath was both uplifting and exhausting. Her name was suddenly everywhere, on magazine covers, on Sunday talk shows, in whispered conversations about the future of national leadership. Supporters hailed her as fearless. Critics accused her of grandstanding. She endured both with the same steadiness that had defined her courtroom presence. Knowing that public attention was fickle but principle was enduring, she returned often to Rosemont County, not for cameras, but for the people whose voices had been restored. At one town hall, an elderly woman stood up and said, "I voted last week without waiting 3 hours for the first time in years. Thank you." Crockett's eyes softened as she replied, "Don't thank me. Thank yourselves for never giving up." The threats continued, but so did the letters of gratitude. For every anonymous message meant to intimidate, there were dozens, from ordinary citizens, each one a reminder that courage multiplies when shared. Late one evening, Crockett walked alone past the Lincoln Memorial in Washington. The marble statue loomed in silence, carved words of equality and freedom etched into the walls around her. She thought of the applause, of Kasubhai's ruling, of the students in the gallery who had witnessed history firsthand. She thought of her own fear, and of how she had refused to bow to it in that quiet moment. She realized the case had given her something greater than recognition. It had given her proof that democracy was not fragile when defended, it was resilient. It had shown her that even in times of division, there were still chambers where fairness could triumph, and still people willing to stand and cheer for justice. She whispered to the statue, but really to herself, "This is why we fight. This is why we keep going." And so the story of Judge Kasubhai's respect, of the chamber's applause, of Jasmine Crockett's courage, lived on not as a single victory, but as a chapter in the unfinished book of American democracy. A reminder that the right to vote is more than a legal mechanism, it is the heartbeat of a nation. And every time that heartbeat falters, it will take courage, loud, unflinching courage to restore its rhythm.